Hello. Today, I'd like to talk to you about copyright and licensing considerations for choirs, specifically those within Canada. This is a very important topic and one which I think is largely unobserved and perhaps even generally avoided. However, it is law and it also supports our artists' livelihoods, so it is something that I think all choir organizations should be acquainted with and compliant with. Before we begin, I'd like to make it clear that although I have read the Canadian Copyright Act a number of times, I am not a lawyer, and anything that's said within this video should not be construed as legal advice. Even legal firms, when making similar presentations, will offer disclaimers, for you see, the law is both simple in its design and intent, but complex in the application of its exceptions and exemptions. What I will offer here is a review of basic terms and a handy flowchart guide for your consideration. The very first thing that we have to identify is whether the work that we would like to perform or reproduce is actually in the public domain and what that means. In Canada, a work is considered to be within the public domain if 70 years have passed since the death of the last contributing author. So for choral music, that includes both composers and lyricists. In the United States, that test is a little bit different depending on when the work was created or published. Protections can sometimes last as long as 120 years. The Wikipedia page for public domain in the US offers a credible source of summary information. There are other ways that music can enter into the public domain. Copyright holders can waive their rights, or they can make their work available with select restrictions based on the Creative Commons model. You can also read more about that, too, on Wikipedia. That being said, it is up to you to practice your own due diligence. I would highly recommend that choral organizations insert a column in their spreadsheets or a database field perhaps in their library catalogs to indicate whether that piece is actually in the public domain or not, and perhaps also identify when it will potentially enter into the public domain. So what is copyright? Well, copyright is a right of reproduction. In Canada, any time a work, also known as intellectual property or IP, becomes fixed in a tangible form of expression, then it is automatically afforded copyright protections. There is no longer any need to register with the Copyright Office in Ottawa, so that means that the author of any given work will be initially and automatically granted copyright rights. As you can see from this slide, there are different types of intellectual property that can be covered under this definition. The ones that we're going to be focusing on today are musical compositions and sound recordings. Now, these rights have everything to do with protecting the IP from anyone copying or creating derivative works, such as arranging or sampling, and controlling how that music is distributed and performed. In other words, any form of reproduction. There are different types of licenses, including print, compulsory, performance, mechanical, and synchronization, and we're going to cover a few of those terms in just a moment. This is the main slide, which I'd like to review. If you are a performing choir, this chart will be a helpful guide. So back to our first question, is the work in the public domain? If it is, and you wish to arrange or perform or record or broadcast in some form, you can see in this column that there's nothing more you need do. It doesn't matter if the music was purchased, transcribed, downloaded. You can copy, arrange, sample, distribute, do whatever you wish with it. No fees or licensing is required. However, if you're going to perform or reproduce a work that is protected by copyright, there are things that you need to consider. First, you need to identify the copyright holders. So when a new musical work becomes fixed in a tangible form of expression, the author will retain the initial copyright. If that same author becomes deceased, then the estate or benefactors will hold that copyright. If the author, before death, has transferred those rights, let's say to a publisher, then the publisher will retain the rights. If the publisher agrees, under contract, to only hold the title for a set period of time, the copyright will usually revert back to the author. If the author creates an arrangement of a public domain work, then the author is the copyright holder of the arrangement. However, if the author wishes to create a derivative work of a copyrighted work, then they must first secure a permission to arrange, and then their new arrangement will be itself copyrighted to themselves. As an addendum, cover songs, that is, a new performance or recording by a musician other than the original performer or composer of the song, and in which the song remains largely unaltered, particularly in melody and harmony, and whose title has not been changed, cannot normally be stopped from performing or recording the piece, and this is called a compulsory license. But the subsequent forms of licensing will still be applicable. You mostly see this on YouTube. So now that you have identified the copyright holder or holders, the next consideration is how the work is intended to be used. There are three main columns here. If you are performing a musical work that is under copyright protection, either live in a venue or as part of a public indiscriminate broadcast, then a performance license must be purchased. If you are recording a musical work that is under copyright protection onto physical media or into a digital format, or offering that same file for download, then a mechanical license is required. If you are performing or recording a musical work that's under copyright protection and wish to pair it with video, then you must contact the copyright holders directly to obtain a synchronization license, and if publishing to a platform of some kind, must to have a mechanical license attached. Be wary, if you incorporate existing video footage as part of your own video, it too may be copyright protected. So those are the four main categories and the essence of a choir's obligations with respect to music. If it's public domain, then nothing is required. If it has some sort of copyright protection, depending on what it is you wish to do with it, certain licensing requirements and fees are necessary. Essentially, that's all there is to it. Now I know that you're going to have some questions, and I've anticipated some of those, and I'll try to address them here for you right now. One of the questions that arises quite frequently is this: my school choir is performing music that's under copyright protection, and they're doing it for parents at their end-of-term performance in the school auditorium. Am I exempt from a license? And the short answer is no. This is considered a public performance, regardless of the venue. There is an exemption under Canadian copyright law that you may have heard of called fair dealing, but it only applies to the copying or reproduction of small portions of protected works, specifically for use within a classroom setting filled with students, led by a teacher, and intended for instructional, teaching, and learning purposes only. The performance of a complete piece outside of this specific setting requires licensing, even if a teacher believes that it possesses an educational component. That's why, too, most sound recordings played for school assemblies or for morning PA announcements need to be, technically speaking, also licensed. Under U.S. law, this exception is called fair use, and it's a little bit different. So if you are in the United States, you may wish to look more closely at the law there to see exactly what this means for you. The next question is asked a lot: what about photocopies? When you need a couple of extra copies for your choir, let's say the chorister's lost or destroyed the original, surely you can make a photocopy or two. The answer is again, no. Any type of copying in whole or in part is never allowed without the copyright holder's permission. The only exception to this is, again, if you've reproduced a small portion of something for educational purposes specifically for a lesson within a classroom setting with teachers and students. Just another note here, under Canadian law, if a copyrighted work is reproduced for this explicit purpose, all paper and digital copies must be destroyed or erased by teachers and students alike within 30 days of use. Next question. My community choir is performing their concert in a church. We are not charging any fees. Am I exempt? The answer is, again, no. The performance of any copyrighted music inside of a church or similar structure requires a performance license unless it is being used specifically within the context of active worship. Take note that it is possible that the venue itself is already covered by a blanket performing rights organization license from a qualified body. You may recall seeing that on the chart we looked at. For the most part, however, it's only dedicated music halls that have pre-existing agreements and pay annual fees to performance rights organizations, so the performing groups themselves don't have to. It is possible, but rare, that some churches that host concerts regularly may too have this in place, but please verify this for yourself. Again, it doesn't matter if the event is ticketed, solicits donations, is free, or even a private party in someone's home. The tariffs still apply. Here's another question. My choir has recorded a piece that is copyright protected and wishes to upload it to Spotify. What do we need to do? So, Spotify and other major streaming platforms have blanket agreements with rights organizations, such as the MLC in the USA, to collect streaming royalties on the owner's behalf. So you don't need to pre-apply for the streaming of that music unless you're also offering that track for download, and then the mechanical fees will apply. Of course, once complete, you, as the creator and uploader of that new master sound recording, will now hold the copyright to it and may collect your own royalties. All streaming platforms require that you submit music through a distribution service like CD Baby or DistroKid, and they will help guide you in this respect. Next question. My choir has recorded a video of a commissioned choral arrangement of a copyrighted pop song and would like to make it available on our website exclusively for members. What do we need to do? So there are a lot of parameters to this question, but once again, in the spirit of the copyright law, because you have commissioned an arranger to create a derivative of a copyrighted piece of music, they will need explicit permission to do so from the copyright holder. Once that permission is in hand, the choir organization will also need to get a synchronization license from all of the same copyright holders, and even if it's available exclusively for members on your own website, will still require a mechanical license as well. So I guess one of the final questions is, where can I obtain these licenses? Here in Canada, SOCAN oversees and manages author copyright protections. Resound handles neighboring rights, and in tandem will be a choir's primary resource for performance licensing. CMMRA also provides mechanical rights management too. In the USA, the major agencies are ASCAP, BMI, GMR, CSAC, and of course, Harry Fox. They all have websites. I think the main takeaways for choirs, for all choirs in fact, regardless of which copyright territory that you belong to, is that just because you've purchased the requisite number of octavos or digital copies of a copyright protected work, it does not necessarily and automatically confer a public performance right. A license of some type is required. Remember too that it also doesn't matter if you are performing for free, or if you yourself are a charitable organization, or if you're performing in a school auditorium. Licensing applies. I think another key point here, too, is that while the definition of what enters the public domain in Canada is fairly understandable, it cannot be taken at face value for every work. Every single piece of music must be evaluated closely for its true eligibility. Canada also recently modernized its Copyright Act to align more closely with our international treaty obligations. So it used to be in Canada that works would enter the public domain 50 years after the death of the last surviving author. However, this has now been extended to 70 years, but it's not retroactive. So that means anything that entered the public domain before 2023 remains in the public domain in Canada, but anything after is subject to the new laws. So in effect, what that means is there will be no new intellectual property of any kind entering the public domain in Canada until the year 2043. Well, that's my presentation. In summary, practice due diligence to determine whether a work is truly in the public domain or if it falls under copyright protections, and you will then have to decide what it is you wish to do with it and determine what kind of permissions or licensing is required. Be wary. Those exceptions and exemptions we briefly mentioned are limited in scope, and they don't apply as broadly, I think, as many people believe. If you are in doubt, please contact an appropriate lawyer. If you have any questions or comments, corrections, or enhancements that you believe would make this topic clearer or more accurate, then please leave me a comment below, and I look forward to hearing from you. Take good care.